The courtroom fell silent as the jury delivered its verdict. Found guilty on all 5 serious charges, the defendant continued to deny the allegations against him. But the evidence presented in court told a very different story and changed the entire picture of the case.
Did the penis of the defendant penetrate the mouth of... Yes. During the commission of the offense, did the defendant use or threaten to use a deadly weapon? Yes. During the commission of the offense, did the defendant actually possess a firearm? Yes. We, the jury, finds as follows as to count 3. The defendant is guilty of robbery with a firearm as charged. During the commission of the offense, did the defendant personally carry, display, use, threaten to use, or attempt to use a firearm? Yes. During the commission of the offense, did the defendant actually possess a firearm? Yes. We, the jury, finds as follows as to count 4. The defendant is guilty of attempted first-degree premeditated murder as charged. During the commission of the offense, did the defendant personally carry, display, use, threaten to use, or attempt to use a firearm? Yes. During the commission of the offense, did the defendant actually possess a firearm? Yes. During the commission of the offense, did the defendant personally discharge a firearm? Yes. During the commission of the offense and as a result of the discharge of the firearm, did the defendant cause great bodily harm to... Yes. We, the jury, finds as follows as to count 5. The defendant is guilty of robbery as charged. So say we all, dated this 13th day of August, 2026, signed by the foreperson of the jury.
Let's use numbers.
Jury number 4, is this your true and correct verdict?
That's not the right jury.
That's the number you had me beat.
Oh, yes.
Jury number 6, is this your true and correct verdict?
Yes.
Jury number 12, is this your true and correct verdict?
Yes.
Jury number 15, is this your true and correct verdict?
Yes.
Jury number 17, is this your true and correct verdict?
Yes.
And jury number 25, is this your true and correct verdict?
Yes.
All right, so sit down, Mr. Killins. So there's a all right, so Rich, I want you to take the jury into the jury room.
Jury exiting courtroom.
What's going on, Mr. Killins?
Lying, man. I ain't do no like that.
All right.
To that. I don't want to tell Naya and them
Out.
what happened, man.
He goes in the holding cell. Make sure the closed circuit TV is working. Mr. Hackworth, I don't want you to go in, but I want you to go back in a few seconds and make sure the closed circuit TV is working that we've had set up.
Yes,
and
ma'am.
he's going to watch this part from in there.
Yes, ma'am.
Okay.
Do you want me to take his stuff back too?
No.
Okay.
I'll let my bailiffs do it.
No problem. Take my pen back. I'm gonna give it a second.
Yeah. All right, let's take a look. Under the prison releasee reoffender, we have to put in, you have found Joseph Killins guilty of. You're probably a faster typer than I am, both of you youngsters over there. So if you could type those in and then just send me that one, because I've got everything else set up.
What's the vibration?
It's 3.16. John, you want to go back and just eyeball? Rich, is all our stuff working? Remember, I've got a second phase of this. I just didn't get to tell the jury that before he started acting up. Okay? So they can't have their stuff yet. Do we know, I need John to be able to confirm that the closed circuit is working.
Let me check.
Is he like secured?
I believe so. I haven't been back there with him.
Oh, wait. Are you guys just gonna put the 5 minutes? Can you guys let me know if he's safely?
Just let me know when you're receiving. Judge, may I step outside to see if our...
You may.
Jerry, you come back.
Ladies and gentlemen of the jury, the defendant, Joseph Killins, is a who robbed and terrorized, victimized 4 women between April 18th and April 19th of 2023. The evidence in this case comes in the form of videos and maps and several witnesses, and that can prove to be overwhelming. So the purpose of talking to you in this closing argument is to address some of the things we've heard from all of those witnesses, to address the narrative that the defendant has just given you about his experience and what he alleges the evidence, having had the last several years to review every police report, every statement, having had the opportunity to sit before you and listen to each of those witnesses testify about what happened to them, what his version of events was. We'll have an opportunity to discuss that, why it doesn't match the evidence. But I want you to think back to Mr. Hackworth's opening statement. Actions speak louder than words. Utilize your common sense in this particular case. Think about how each one of the victims who took the stand reacted. What was their demeanor? What did they tell you about what happened to them? But more importantly, think about why on earth each and every single one of them would have gotten on the stand to testify about the most horrific experience they have ever had, to sit in the same courtroom with the person who caused them that trauma, with cameras and a bunch of strangers. For what? What benefit have to having to take the stand and relive being forced to give oral sex to a stranger who had abducted her while she was working her second job? Think about the defendant's testimony as we go over each of these items of evidence. Her second job. She's a 20-year-old student and works 2 jobs. Left her first job after 10 o'clock at night to go make extra money to survive. And the defendant asks you to believe that she ran into his arms and disregarded a pizza into a parking space because she was so overwhelmed with the amount of love that she has for Big Head, his nickname. That she was just so overwhelmed, she jumped onto his person, forgot about her job, forgot everything. Everything he testified to had some kind of explanation because she was just so in love with him. That's why his DNA is all over her face and all of these things. Keep in mind his outlandish statements as you review and consider the evidence that you'll take back with you. Keep in mind the courage that it took for each person to take the stand and testify about what happened to them, physically, mentally, and emotionally, because they came into contact with one person, Joseph Killins, and how that affected and changed their lives forever. He got on this stand and provided a statement that was so unbelievable. But let's point to the facts so that I can assure you that there is no question about the statements that each and every single one of those women told you when they came into this courtroom. Because at the end of the day, during a traumatic event, your mind does not record memories like a video. Each and every single person that he victimized got in here and told you what they saw, what they witnessed from their vantage point when he did it. Your mind records and stores the memories of what you experienced in that moment. But remember that what the memories are that are stored are the facts that matter, because the facts that matter in this case did not change. They all were consistent with the evidence that was provided to you, with the exception of the defendant's statements. They all were consistent with what happened to them that night. And when we are about to go over the video evidence, and you'll actually see the timeline and have an opportunity to see the timestamps and the time frames from which you see the defendant on camera and then the victims are having contact with law enforcement, there was no way anything other than the victim's statements of what occurred that night happened. There is no way that anything other than Joseph Killins committing an abduction from that residence inn occurred. And Joseph Killins forcing to drive around for 2 hours before taking her to that apartment complex occurred. Don't rehash the questions that were asked. Why didn't you throw yourself from the moving vehicle as he nodded off to sleep? That is not any of the options the judge just read to you on your verdict form as to whether the state has established that these acts occurred. Those are distractions. Same thing with, did you say in your deposition that he had little hair and beard and crazy eyes, or bald little hair? None of those elements of the crime. None of them. You had 4 individuals who, English is their second language, came in here and told you the same statements they told law enforcement 3 years ago. They provided through all of their testimony, through the physical evidence in this case, exactly what happened to them. And they have no reason to not be telling you the exact truth. First amount of footage you have in this case comes from the video surveillance. After the vehicle from aviation leaves the scene of the shooting and goes to the entrance, it is 1:05:35 a.m. The video from the apartment complex next door, Haven, that we saw, from that parking lot where the defendant jumped over the fence, happens, and you'll see as the clock ticks down, the second aviation realizes that's your victim and points back to the original shooting scene. They've just missed the defendant who's hopped over the fence and gets away. The fence is the fence line between the 2 apartments. And the defendant testified that he ran through the buildings and ran away. He jumps over the fence, although he also changed that and said that that's not him in the videos. That's fine, but this is the path of travel to the fence line where this video captures. The path of travel starts where the shooting occurs, where the defendant admits he was on the aviation video. And this video captures the defendant jumping over the fence at 1:05:30, just as the first victim is making contact with the officers at the front of the complex. Seconds later, captured on the next camera to the west. When he's captured on this camera, just as was pointed out, when Detective Baranowski was actually, was actually on the stand. He looks up at the aviation. He's holding his pants in the exact location where says he had a gun and was forcing her to perform oral sex on his person.
Welcome to my channel, Courtroom Cases.